Tonight, President Trump speaking out after another alarming security threat.
I don't know how long I'll be around. Got a lot of people gunning for me, don't I, huh?
The president was at the White House early Sunday as law enforcement agents shot and killed an intruder at Mar-a-Lago. Two law enforcement sources identifying the suspect as 21-year-old Austin Tucker Martin from North Carolina. Now, investigators are trying to determine why he allegedly breached the property's security perimeter around 1:30 a.m., carrying what appeared to be a gas can and a shotgun. Police say he was ordered to drop them.
He put down the gas can, raised the shotgun to a shooting position. At that point in time, the deputy and the two Secret Service agents fired their weapons.
President Trump was at the White House early Sunday morning when law enforcement had to respond to an intruder at Mar-a-Lago. The suspect, 21-year-old Austin Tucker Martin from North Carolina, cut through property security around 1:30 a.m., carrying a gas can and a shotgun. When officers ordered him to put the weapons down, he raised the shotgun instead. A deputy and two Secret Service agents opened fire. But that's not the story that's about to shake the political world. There is reportedly surveillance footage of Trump directly instructing a staff member to destroy financial records that were under a federal preservation order, on tape, telling an aide to wipe those ledgers, months after a federal judge had explicitly ordered every one of those records preserved as key evidence in a fraud case carrying a judgment of roughly $1.5 billion. After reviewing that footage, a federal judge has issued one of the harshest court orders ever directed at a sitting president. The ruling uses the term blatant spoliation, authorizes criminal contempt proceedings, and sets escalating daily fines of up to $500,000. And in no uncertain terms, it puts obstruction of justice charges and possible criminal prosecution squarely on the table. This isn't a legal technicality. This is a federal judge watching surveillance footage of a sitting president ordering the destruction of evidence and responding accordingly.
Well, he does, and I think most Americans look at this and they can see that this is an attempt to make sure that Donald Trump is somehow chased off the ballot. But in their attempt to do it, it's sort of like Wile E. Coyote going after Roadrunner. The more they try, the worse it gets for Wile E. Coyote, the better it gets for the Roadrunner. His numbers stay up. People look at this and they say, wait a minute, let me see if I get this right. You do a raid on his home over some pieces of paper. Hillary Clinton, who had no authority whatsoever to have documents, had erased 33,000 emails, kept a private server in her bathroom. Some of those emails, private, classified stuff, ended up on convicted felon Anthony Weiner's laptop. So the double standard here is stark. And they're going after not just Donald Trump, they're going after people who work for him. Look, I'm just amazed by all of this. It's stunning.
What we're witnessing right now is genuinely unprecedented. A federal court has surveillance footage that appears to show the President of the United States personally ordering the destruction of documents that a judge had explicitly told him to preserve. This isn't a case of a low-level staffer accidentally deleting files. This is Trump, on camera, telling a staff member to wipe those ledgers, months after a federal preservation order was issued in a fraud case, carrying a judgment of roughly $1.5 billion. And it doesn't stop there. A former staff member accepted an immunity deal and testified under oath that Trump directly instructed him to destroy both physical ledgers and digital files. That testimony aligns perfectly with the footage. Together they eliminate every defense his lawyers would normally reach for. There's no out-of-context argument left, no claim that he didn't know. A cooperating witness who was in the room confirms exactly what the video shows. The judge's response was swift and unambiguous. The ruling describes the conduct as blatant spoliation, authorizes criminal contempt proceedings, and imposes escalating daily fines of up to $500,000. That's $3.5 million a week, $14 million a month, piling up every single day until he complies. And unlike civil judgments, these fines can't be negotiated away or discharged in bankruptcy. For someone already facing a $1.5 billion fraud judgment and acknowledged liquidity problems, that financial pressure is relentless and compounding. But the fines aren't the most dangerous part. The judge has explicitly put obstruction of justice charges and criminal prosecution on the table, and that changes everything about this case. Previous legal battles against Trump, the New York fraud case, the classified documents, were built on paperwork, financial records, witness accounts, evidence that requires interpretation. evidence defense attorneys can challenge and create doubt around. Video is fundamentally different. You hit play and watch him incriminate himself in real time. There's nothing to interpret, nothing to spin. Jurors see it, the public sees it, and no amount of legal skill changes what's on that footage. There's also the legal concept of adverse inference to consider. If the court determines Trump intentionally destroyed those records, the judge can instruct the jury to assume the destroyed documents contained evidence harmful to Trump. The act of destruction itself becomes proof of guilt. The absence of those records ends up screaming louder than anything they might have contained. This didn't happen in a vacuum. Courts have been watching Trump's pattern of behavior for years. Violated gag orders, contempt findings, defiance of immigration orders, repeated document production delays. Judges notice patterns. They factor them into how much patience they extend and how harshly they respond. Trump has spent years burning through every last bit of goodwill with the judiciary. This video was simply the moment that exhausted whatever remained. The judge wasn't interested in giving him another chance because Trump's own conduct eliminated any basis for that kind of courtesy. For prosecutors, the calculation has fundamentally shifted. Normally, the political risk of charging a sitting president might outweigh even a strong legal case. But when there's clear footage of the defendant ordering evidence destruction, a prosecutor who walks away faces their own credibility crisis, accused of giving the most powerful person in the country treatment no ordinary citizen would ever receive. The video doesn't just strengthen the case, it creates political pressure to act on it. Trump has spent years treating court orders like suggestions, brushing aside preservation orders, ignoring gag orders, treating contempt findings as minor inconveniences on the road to his ultimate win. That approach worked as long as the evidence remained ambiguous enough for his lawyers to manufacture doubt. Video eliminates ambiguity. The judge has seen the tape. The cooperating witness has testified. And now there's an order on the record treating Trump not as a routine litigant, but as someone who deliberately and willfully destroyed evidence. He was caught on camera. The evidence is undeniable, and that footage isn't going anywhere.
Well, there is exactly one first lady in history who met sex trafficker and raper of children and good friend of Donald Trump, Jeffrey Epstein. And today, Republicans on the House Oversight Committee decided to question a former first lady who never met Jeffrey Epstein instead of the first lady currently occupying the White House, who was friends with Jeffrey Epstein and his convicted sex trafficking co-conspirator, Ghislaine Maxwell. Donald Trump's third wife was friends with both of them. The Epstein files contain emails from Melania Trump to Ghislaine Maxwell complimenting Ghislaine Maxwell. The Epstein files contain no communication at all between Hillary Clinton and Jeffrey Epstein or Ghislaine Maxwell, but Republicans on the committee decided they wanted to subpoena Hillary Clinton. Where is their subpoena for Melania Trump, who actually knew Jeffrey Epstein and Ghislaine Maxwell? Why aren't they asking Melania Trump? Did Donald Trump introduce you to Jeffrey Epstein, or did Jeffrey Epstein introduce you to Donald Trump?
Now, shifting gears a bit, let's talk about the impeachment situation. With all the noise out there about various charges and high-profile articles, it turns out this impeachment really doesn't have the votes to succeed. It's more like political drama than anything else, lacking real support to remove Trump from office. What we're witnessing is Democrats pushing articles that probably won't pass the House and would face serious hurdles in the Senate even if they did. This situation highlights how broken our political system has become, along with how impeachment has turned into just another political weapon instead of the crucial constitutional process it's meant to be.
Why aren't they asking Melania Trump what she knew about Jeffrey Epstein? The Epstein files show the Palm Beach police chief saying that Donald Trump told him in 2006, quote, "Thank goodness you're stopping him. Everyone has known he's been doing this." If true, that would mean that Donald Trump's wife at that time, Melania Trump, knew he was doing this. She would be included in Donald Trump's term, everyone. Melania Trump might have no useful information to provide to the committee, but she did meet Jeffrey Epstein. She was friends with Jeffrey Epstein.
Now, let's be honest about the impeachment situation. because the reality is a lot less dramatic than the headlines suggest. Despite all the noise, these impeachment articles simply don't have the votes to succeed. What we're watching is political theater more than a genuine constitutional process. Democrats are pushing articles that likely won't clear the House, and even if they somehow did, the Senate would be a wall they can't climb. The votes aren't there. And that's the real problem here. Impeachment was designed as one of the most serious tools in the constitutional toolbox, a last resort for holding a president accountable for genuine high crimes. What it's become is something else entirely, another weapon in an already exhausted political arsenal, wielded more for messaging than for actual removal. That's not what the framers intended, and it's a sign of just how broken the system has gotten. Let's cut through the noise and talk about what's actually happening with impeachment, because the reality is very different from the headlines. House Resolution 353 was introduced in 2025, charging Trump with obstruction of justice over the Epstein files, abuse of power, and events surrounding January 6th. Democrats are building their case. The White House is calling it a witch hunt, and the media is treating it like it's building towards something real. It isn't. At least not yet. Here's what's actually true. The resolution hasn't been voted on. It doesn't have majority support in the House. And if we look at history, a nearly identical resolution, HRES 939, was tabled with a vote of 237 to 140. There's no reason to expect this one ends differently. A lot of heated debate, no real momentum, plenty of political theater. And even if it somehow cleared the House, the Senate math is brutal. Conviction requires 67 votes, a two-thirds supermajority. Democrats hold 51 seats. That means 16 Republican senators would need to break with their party and vote to convict a president their own base overwhelmingly supports, knowing full well they'd face primary challenges and political consequences for doing so. Betting markets are putting the odds of conviction at 14% by year's end. The professionals aren't buying the narrative either. Trump's approval rating sits somewhere between 37 and 43%, depending on the poll. Not great, but not collapse territory. Other presidents have governed through similar numbers. His cabinet isn't invoking the 25th Amendment. Nobody in his inner circle is calling for resignation. The institutional mechanisms that could actually force him out simply aren't aligned for that outcome right now. So why are Democrats pushing impeachment if they know it won't succeed? Because impeachment doesn't have to succeed to serve a purpose. It generates headlines. It keeps Trump on defense. It signals to their base that they're fighting back. And it keeps the conversation about presidential misconduct alive in the news cycle heading into 2026. It's a messaging strategy dressed up in constitutional language. And that's exactly what makes it disheartening. Impeachment was designed as a serious constitutional safeguard, a last resort requiring broad bipartisan consensus to remove a president who has genuinely crossed the line. What it's become is a political weapon that both parties reach for when they want to score points, fully aware the outcome is predetermined. That's not how the framers envisioned it working, and it's a pretty clear sign of how broken the system has become. The real threats to Trump's presidency aren't coming from impeachment articles that lack the votes. They're coming from the Iran crisis, the government shutdown, the Supreme Court striking down his tariff regime, courts blocking his executive orders, and an approval rating that keeps hovering in territory that makes 2026 look dangerous. Those are the pressures that actually matter. Impeachment, in its current form, is background noise, loud, dramatic, and ultimately going nowhere.
More than 3 million pages, 2,000 videos, and 180,000 images. CNN teams are carefully sifting through the largest, and what the Justice Department says is the last, batch of Jeffrey Epstein files. It's an enormous trove of documents, and it includes references to some of the richest and most powerful people on the planet. That includes the current president, a former president, cabinet secretaries, a former prime minister, billionaires, and the list goes on and on and on. The Justice Department says tonight that its job is done.
We complied with the statute, we complied with the act, and there is no, we did not protect President Trump, we didn't protect or not protect anybody. I mean, I think that we there's a hunger or a thirst for information that I do not think will be satisfied by the review of these documents.
Now, when the release happened on the 1st of February, there wasn't any drama or panic to be seen. No one stormed out of a press conference, contrary to what some sensationalized clips might suggest. What actually unfolded was much more intriguing and significant. It's about institutional power, political strategy, and who gets to dictate the narrative in Washington.
I should note that just because someone is mentioned in these documents does not mean that they've been accused of wrongdoing or did anything wrong. Many of these claims are unverified or they rely on secondhand information. But these are the key findings our team has uncovered so far, and I should note, millions of pages have come out. We are still digging right now in this hour. Donald Trump's name appears thousands of times in these new documents. In some, he's merely mentioned in emails that Jeffrey Epstein sent to other people. But the files also contain a complaint from a woman who accused Trump of raping her in 1994 when she was just 13 years old. According to the FBI document, this accuser, who is identified as Jane Doe.
When the release happened on February 1st, there was no drama, no panic. Nobody stormed out of a press conference. Contrary to what some sensationalized clips would have you believe, what actually unfolded was far more interesting than that. This is really about institutional power, political strategy, and the one question that matters most in Washington right now: who controls the narrative? When the Department of Justice dropped over 3 million pages of Epstein-related documents on February 1st, there was no drama, no panic, no meltdowns at press conferences, just a massive document release that was supposed to signal transparency and immediately created more questions than it answered. That's the real story, not the sensationalized clips recycling old footage and dressing it up as breaking news. The actual shift happening here is institutional, strategic, and consequential. The administration framed the release as proof of cooperation. Democrats responded almost immediately by pointing to an NPR report confirming that Trump-related pages were still missing, withheld from the public release. And then Deputy Attorney General Blanche confirmed there would be no new charges stemming from the released documents. That confirmation, meant to diffuse the situation, actually made things worse. If there are no new charges, what exactly is still being protected? That's the question Democrats are now pressing. And it's a fair one. The administration finds itself in a bind of its own making. Releasing 3 million pages was supposed to end the conversation. Instead, it shifted the focus entirely from what was released to what wasn't. Rather than closing the chapter on the Epstein files, the release dragged the story back into the spotlight with a new set of grievances attached. From a political communication standpoint, that's a failure, regardless of whether the legal reasoning for withholding certain documents is sound. And here's where it connects directly to the impeachment process. House Resolution 353 is gaining real traction, 287 votes, with 42 Republicans breaking from their party to support it. That's not YouTube commentary or partisan speculation. Those are actual votes with real political consequences. When Republicans start crossing the aisle in those numbers, it signals genuine fractures within the party, not just surface-level discontent. The Senate is the next battleground. Conviction requires 67 votes. Democrats hold 51, meaning 16 Republicans need to cross over. The House defections suggest the cracks in party unity are deeper than usual. Kash Patel's testimony around document withholding is giving Senate Republicans political cover to ask harder questions. And with the DOJ review still ongoing, more revelations about what was actually held back could keep building momentum heading into the Senate vote around March 1st. Meanwhile, the broader institutional picture keeps deteriorating. The Supreme Court rejected Trump's tariff executive order. The FBI director's credibility is under fire. Republicans are splitting in Congress. And the Epstein file situation feeds directly into an obstruction narrative that's gaining ground precisely because trust in this administration has collapsed to the point where even technically correct explanations land as defensive and suspicious. That's the real challenge. This isn't just about documents anymore. It's about whether an administration with this level of credibility erosion can make any argument, legal or otherwise, that Congress and the public will actually believe? Right now, the answer seems to be no. And with the Senate vote approaching, that perception gap may matter more than any individual fact in the file. The sensationalized coverage is a distraction. The actual story, institutional fractures, real congressional votes, an ongoing DOJ review, and a Senate impeachment vote on the horizon, is significant enough without any added drama. That's where the consequences lie, and that's what's worth watching.